All right. What is going on, everybody? We're here today. This is going to be one of those kind of like wild cases. Can you guys hear me okay? I got audio now, I hope. It looks like it's broadcasting. Hold on. All right, there we go. All right, yeah. So it always takes good. So what we're going to be looking at today is if you've ever heard me quote the case of, let me mute this for just a second. They're not even ready to start. But have you ever heard of the court case, Mcdonough versus Fernandez-Rundle? Well, this is the guy right here. I'm going to, hopefully you guys got the link in chat. And if not, check the community. Let's all join in here. We can all jump in here and actually listen and watch this at the same time, but we'll broadcast it here. But it'll look really good if you guys have everybody in this Zoom meeting here. So give me 1 second. Get it from over here. Not a broadcast major. I don't know how this stuff works. All right. So the lady. So if you look at the lady in the top there, the one that she's Hispanic, has basically the mini blinds in the background. She's the only one on camera. That's the clerk that is being ultimately sued here. So. And he's doing this pro se. This case has been going on for 2 years. 2 years. And a lot of times when the people are saying, like, you need to sue, well, this is it. There is over $200,000, if I remember correctly, in litigation up for, the penalties of it. If he loses today, he owes the city an excessive amount of money. And this is it right here. This is the trial. So let me get that streamer. Everybody join in this if you can. And you just jump in there. I'm in there as well. You can see me under James Madison. I'm getting ready to copy it in here into the chat. I'll read some chat. When they start, we're going to mute. And if you do come in, just be respectful and mute your mics when you come in. Yeah, so this case does not give you any damages. All it is setting precedent here. That's the trouble with these public case laws. If he wins, he gets his reasonable attorney fees. If the city wins, the city gets over upwards in $200,000 to $300,000, if I remember correctly, from him, from Mr. Eric Mcdonough. Let's see. So this starts at about 10:30, and we're going to be in here. So this is all about a public records violation. There he is right there. That's Mr. Mcdonough. He looks like a judge to me, doesn't he? He's the one in the middle with the bald, shaved head. I'm so happy to see him. We talked last night, so if you guys can click that link in there and just join in, I would really appreciate it. That way we can. We're not going to cause any drama in here. We're just going to flood them so that they see that they're being watched. That's what we want. We want to make sure that they're going to be respectful and All right. So he's also being sued here. Rick Rivera is. Now this is really beneficial. If you haven't seen that link up there, scroll up a little bit. If someone else can post it, it says Zoom US. So if you guys do join, can you guys hear the audio from the? Yeah, you guys can hear the audio, right? All right, so what she's doing, if you do join in here, just make your name, whatever you can, so that it's not iPad. Just put your name in there as something. You can see mine is James Madison, so only my audio, not the court. All right, let's fix that really quick. Display capture. Oh, goodness. Why is this not working then? I just had it all set up earlier. Video capture. Let's try that.
Okay, there's several of you that for some reason are refusing to properly identify yourselves. And Jessica, I've heard her ask repeatedly for you to identify yourselves. And I'm going to give you 30 seconds to put your complete name up, or you're going to be removed. 30 seconds.
Sir, I'm just an observer.
I don't care who you are. Either identify
My name's John.
You guys can.
Good morning, Judge. I'm Natasha. I'm your clerk for today.
You guys can
Good
make
morning,
fake names in there.
Natasha.
Just
Thank
make an alias name like I did, James Madison. Just do that. It's easiest if you jump in.
Good morning, Your Honor. My name is Elizabeth Sewell, the city clerk for the city of Homestead.
Morning.
Good morning, Your Honor. This is Emily Scott. I'm the court reporter for the proceedings today.
Good morning.
My name is Zachary Mcdonough. I'm an observer.
Good morning.
Good morning, Your Honor. H. Martin Bermudez, observer.
Okay, Jessica, please remove the individual that's appearing through a telephone number and the other individual that just says Rabir. Oh, there we go.
Sir, my name's John D. Nicola, and I'm an observer.
You're going to put your name up or you're going to get removed.
I'm on a phone. I can't put my name up, sir.
What is your name?
John D. Nicola.
Spell your last name.
D-E-N-I-C-O-L-A.
Got it, Judge. I was able to change him. There's somebody else.
Morning, my name's James Hunt, and I'm an observer.
Okay. I see Mr. Dr. Mcdonough is present. Who represents the defendant?
Good morning, Your Honor. Sam Zeskind and Matthew Mandel of Weiss Rhoda Helpman, the defendant, City of Homestead.
I'm going to give each side 1 minute for an opening statement. Mr. Dr. Mcdonough, you may proceed.
Your Honor, this case is premised on 3 public records requests. It's alleged that the city violated the law. The first, city failed to produce records responsive to my first request until after the instant action was filed, whereas city produced responsive records for my second and third request after the action was amended to include these latter requests. Unjustified failure to respond to a public records request until after an action has been commenced to compel compliance amounts to an unlawful refusal. Weeks v. Golden, 764, Southern 2nd, 633. Having to file and or amend this action to compel compliance imposed undue cost. Florida Statute 119.12, Section 1 states I'm entitled to recoup these costs, and I respectfully request such. Second, Florida Statute 119.07, Section 1A requires an agency to allow inspection and or copying of public records at any reasonable time, whereas the only permissible delay in producing public records is the limited reasonable time allowed the custodian to retrieve the records and delete those portions of the record the custodian exerts are exempt. Promenade de Herberville, LLC v. Sunday, 145 Southern 3rd, 980 at 983. The city has failed to provide any justification for its excessive delays in these three requests, Your Honor. As such, I request that delays be declared unlawful. Third, and at least the first and third request, Homestead has failed to produce all responsive records with the first set of records production. Florida Statute 119.01, Section 1 requires that all municipal records be open for inspection or copying. City has failed to provide any justification for failing to produce all responsive records in at least the first and third request. As such, I request that the failure to produce all responsive records in at least the first and third requests be declared unlawful. Fourth, city has failed to produce all records responsive to the third request, and in order demanding city produce these records is respectfully requested. Lastly, Your Honor, the city has a pattern of unjustified delays in the production of public records and of failing to produce all responsive records or to properly claim an exemption. These patterns create a well-grounded belief that such violations will continue, if not.
Thank you. Defense.
Good morning, Your Honor. This is a public records case that arises out of three distinct public records requests submitted by plaintiff to the city of Homestead. But unlike most public records cases, we're not here today to decide whether plaintiff is entitled to the production of any additional records. While plaintiff's amended petition does contain counts seeking mandamus relief, no alternative writ has been issued in this matter. And Florida law is clear that it would be error to determine the merits of mandamus claim without the issuance of an alternative writ and allowing the city the opportunity to respond. So as a result, there's no claim before the court today that could compel the
Excuse me.
production.
Everybody must be on mute unless you're addressing the court. I'll exclude everyone. You may proceed.
Thank you, Your Honor. As a result, there's no claim before the court today that could result in an order compelling the production of additional records. Instead, the only issues before the court today are plaintiff's claims for declaratory and injunctive relief. With respect to the declaratory judgment claims, plaintiff is not entitled to the relief he's requesting, as what he seeks amounts to improper advisory opinions.
Say that one more time.
The request that he's seeking, the request that plaintiff is seeking in the form of declaratory judgments, are seeking improper advisory opinions. The evidence will show that the responsive records have been produced and that even if plaintiff were to prevail, he cannot be entitled to cost because before filing his complaints, plaintiff failed to comply with the pre-suit notice procedure set forth in section 119.12. As a result, there's no present need for a declaration, and any such declaration would be advisory in nature. With regard to plaintiff's claims for injunctive relief, his claims must fail for two primary reasons. First, the injunctive relief sought by plaintiff is impermissibly overbroad and cannot be awarded by this court. Plaintiff effectively asked this court to enjoin the city from any future violations of Chapter 119. Florida law is clear that such broad blanket orders are not appropriate. Second, in order for injunctive relief to be entered in public records matters, a plaintiff must demonstrate a pattern of non-compliance with Chapter 119, together with a showing of likelihood of future violations. Plaintiff will not be able to meet this evidentiary burden. As for the facts of this case, they're not in dispute. The parties agree on the dates that plaintiff submitted his public records request to the city. The parties agree on the dates that the city produced records in response to those requests. The dispute here is really limited to a single issue, and that is whether it took the city, whether the time it took the city to respond to those requests amounted to an unreasonable and unlawful delay. Sure. It took the city 6 weeks to respond to plaintiff's first request for the city's nepotism policy. And it took the city 6 weeks to respond to plaintiff's request for all emails sent by the city's former city manager that contained the term nepotism. And yes, it took in total 6 months for the city to respond in batches to plaintiff's requests for records related to an investigation performed on him by former city detective Ricky Rivera. And at first glance and without any context, those timeframes may seem long. But reasonableness is subjective, Your Honor, and it cannot be determined just by looking at the numbers. The evidence will show that in light of the extenuating circumstances surrounding the timing of each request, the city did not unreasonably delay its response. The evidence will show that the first request coincided with the busy election cycle and a high volume of other public records requests.
Thank you.
Which, Your Honor, can I have 30 more seconds?
All right.
Which impacted the city's response time. And with regard to the other two requests, the evidence will show that they were made during the pandemic, while the city had to operate remotely and in shifts and deal with health issues, which impacted the timing of the city's responses to those requests. Once you have heard all the evidence and arguments, the city believes that Your Honor will conclude that plaintiff is not entitled to the declaratory and injunctive relief sought.
What is the statute section that you contend precludes the plaintiff from relief? Florida Statute 119 what?
In terms of his entitlement to costs, Section 119.12, which provides for notice to be given 5 days in advance.
All right, while he's looking this up, he's reading a statute that indicates that that Eric Mcdonough is not entitled to injunctive or the relief here.
Doctor, call your first witness. I can't hear you.
You're on mute.
Sorry, Your Honor. Your Honor, I'm my primary witness, and as such, I request to be sworn in and allowed to provide my testimony in narrative
Raise
form.
your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Put your hand down. Tell me your name.
Dr. James Eric Mcdonough.
Are you located in the state of Florida at this moment?
Yes, sir. I'm in Miami-Dade.
Proceed.
Your Honor, I would like to offer is evidence Exhibit 1. I affirm this is a true representation of the email chain between me and the clerk's office related to the first request. If I may share my screen. Is it okay for me to share my screen with the first exhibit, Your Honor? Thank you. Your Honor, this is my plaintiff's Exhibit 1. I'll scroll all the way down to the bottom so we can see the full exhibit. That's the bottom. Your Honor, we can see that on Thursday, October 31st, 2019, I filed a records request.
One moment. Defense, do you object to these exhibits?
No objection to the exhibit, Your
They're
Honor.
admitted.
Thank you. Your Honor, you can see that I filed this records request with Elizabeth Sewell, who is the city clerk and the designated custodian of public records for the city of Homestead on October 31st, 2019. And I requested under Florida Statute 119 copies of the nepotism policy, which was allegedly changed in April 2006. I'm scrolling up a little bit. This is a response from the city that was sent on December 13th, where they provide me a copy of a nepotism policy, but it's the 2011 nepotism policy, not the 2006 policy I had requested.
Well, wait a second. You didn't request the 2006 policy.
Yes, sir, I did.
That's not the way I'm reading the request. You're requesting the nepotism policy, which you say changed in April 2006. You're not saying give me the policy that was in effect in 2006. So
I was trying to ask for the
We,
policy.
we read this differently. You may continue, but I'm not reading this as a request for the 2006 policy. Do you understand me?
Yes, sir, Your Honor.
Excellent.
On December 12th, I filed this action. The next day, on December 13th, the city produced me a copy of the 2011 policy.
Objection, Your Honor. Lack of foundation, lack of predicate. He
I'm
is
sorry, who's speaking?
Mr. Matt Mandel. I'm handling this witness on behalf of the city. Your
Who do
Honor.
you represent?
On behalf of the city, Your Honor, I am counsel for the city.
I'm sorry, and what is it that you're objecting to?
I'm objecting to, he's testifying that what was produced to him was a 2011 nepotism policy. I'm objecting as to lack of foundation, lack of predicate. He hasn't established that what's been produced, he hasn't shown.
He's testifying that that's what was produced. You're welcome to cross-examine and show otherwise. I don't understand the nature of your objection. What is your objection? That he's wrong?
That he's testifying as to something that he doesn't have knowledge of. He's saying that what was produced was the 2000.
Your objection's overruled. You'll cross-examine if you wish.
Will do.
Doctor, you may continue.
Thank you, Your Honor. I'm scrolling up to show I responded on the same day on December 13th to the city clerk, and I explained to her that she had provided a copy of the 2011 policy, and it was the April 2006 policy that I had requested, and I asked for immediate production of the remaining policy. We can see here on December 16th, 2019, Ms. Sewell responded and provided the responsive policy. I'll go ahead and stop sharing this now. Your Honor, after more than a year and a half, city has still not provided a justification for its more than 6-week delay or its delay in providing the record until after the action was filed.
Doctor, I'm just not reading it. You requested a policy and they sent you a policy. You didn't request the 2006 policy. All you said is the policy changed in 2006. Let me have it.
In Your Honor, following your interpretation, I will not argue that. What I'm trying to establish here is that the city didn't produce even the 2011 policy until after I'd filed the action and more than 6 weeks after I'd filed the request. And so this goes to the delay and whether the delay was justified or not.
Show me the exhibits again.
You may bring the exhibit 1 up, sir?
Yep.
Yes, sir, Your Honor. 1 second.
Start at the bottom and scroll up slowly, and I'll tell you when to scroll. Start at the bottom. Okay, scroll up. Stop. Scroll up. Stop. Okay.
You want me to continue scrolling, Your Honor?
Yep. Thank you.
Would you like me to stop sharing?
Yep.
Okay, thank you, Your Honor. So I was saying, Your Honor, after more than a year and a half, city has still not provided a justification for its more than 6-week delay or its delay in providing the record after the action was filed. This record was identified with sufficient specificity to allow rapid retrieval. For example, after filing this action, I was advised that the council minutes and agendas were published online. In a time test, I retrieved the responsive document with 10 steps in only 2 minutes and 36 seconds. This was done.
Say that again?
After the lawsuit was filed, a friend had advised me that the city council minutes, and agendas were published online and they could be searched online.
Objection, Your Honor. Hearsay.
Sustain.
Move to strike.
Granted. You may proceed.
Your Honor, I did a test to see if I could find the record and how long it would take me to find the record. I was able to retrieve the record in 10 steps in 2 minutes and 36 seconds.
Okay.
This was done without the city's instant access to its network, without its ability to text search documents electronically, and without the use of Boolean operators. Anyone with said access could have done a simple Boolean search string, i.e. April space and space 2016 space and space nepotism, hit enter, and in seconds or less, the file would be in their possession. I do this routinely as a primary patent examiner for the United States Patent and Trademark Office. I explicitly note for the record, I am here strictly on my own accord, having nothing to do with my official employment. Why this even has to be noted, Your Honor, is the withheld records show that my employer was contacted attempting to have me fired and or to gain intelligence on me because I spoke out and wrote publicly against corruption.
Your Honor,
What does that have to do with this case? Out of
relevance,
curiosity?
strike, relevance.
What's the relevance, doctor?
The relevance is I was trying to explain how I was able to quickly find this record. And if I could find this record in 5 minutes,
Thank you.
city's 6 weeks.
I don't find any relevance to your suggestion that anybody's trying to get you fired. I'm striking that. I'm sustaining the objection, and I'm striking that. What else?
Okay, Your Honor, in the records they provided me were emails from
Jessica. Jessica, somebody is appearing as me,
Yes.
and they're making noise. They're not on mute. Remove them, please.
Your Honor, also, Your Honor.
I'm sorry?
Your Honor, people are also posting on chat and disparaging remarks about Your Honor as well.
Yes, I just seen that also, Judge.
Let me see, one moment.
They should be removed if they are.
Okay. Let's remove me. Jessica?
You have to do that. Remember to get your removed.
Here's what I'm going to do. I don't know who you've brought here today, doctor, but Jessica's going to send a new link.
Okay.
And you're welcome to appear. Defense counsel is welcome to appear. And witnesses that are being called to testify are welcome to appear. The court reporter, the clerk is welcome to appear. No one else may appear. This is
Yes, sir,
just
Your Honor.
nonsense. This is
I
just
apologize. Your Honor.
utter nonsense. Infantile.
I concur with you, Your Honor.
All right. Well, Jessica will send you a new link and we'll log back on in just a moment after everybody else has been removed.
Yes, sir, Your Honor.
Okay.
Jessica, can you send it to Rodney, please?
Jessica, send it to Rodney.
Yes, Judge.
Well, I'm not happy about that. You guys right there, I don't know who did it or what. You know, when you come in there, I say mute the mic and things like that. Now we can't watch anything. Now we can't watch anything. That's there we go. Is that better? All right. What I was going to say is that when you guys are coming in there, not you, not everybody. There's a few people that are going in there, and this is not a court case between Mr. Mcdonough and, or sorry, you guys and Mr. Mcdonough. This is him and Mr. Mcdonough. This is Mr. Mcdonough and Homestead and the court. So yes, it is a public trial. It's going to be recorded and availability there. But when people are, you know, commenting about disparaging remarks in there, this is where these Zoom meetings are going to get us kicked out. Now we can't watch anything. We can't see anything. We can't hear anything. And here we are. So that's how that goes. And you can say what you want in chat. Yeah, it would be made available. I have warned, Richard. I've warned everybody. Keep it respectful in there. It's no different than yelling at a courtroom. You just don't act up stupid like that when it's not the time to do. It's not about anything about truth. It's about being. We were able to be in there and do that. Maybe we'll see if we can do a who ended chat. Who enabled chat? They enable chat because it's just part of the Zoom meeting. This is all new to these people. They was warned. The judge warned. He says, "Don't do anything." Yeah, probably a troll doing it on purpose, but they don't care. They're someone there to disrupt court. And Eric Mcdonough is going to take the brunt of it. He's going to say, as you heard in there, I don't know who you brought in here. So those people, yes, it will be made available. It will be made available afterwards. I can get it for him. I will be able to get it. There's no way that they cannot keep this out here, especially after doing that. So he's right in a sense that they said that, but at the same time, when they did this here, we want to be able to examine and see what is going on with this case. So we should be able to get a copy of it. So I'm sad about this. This is it's not YouTube chat, guys. That's why I did this right here. Thank you for subscribing. Can't see the names of the colors. Oh, Bob, thank you. So unfortunately, that's where we're at right now. We're stuck with nothing, and we have absolutely nothing. We had a good thing going, and then the people had to go in there. When you go into those things like that, you mute. But this is going to be coming. I only hear clicking and speaking. It's probably your side. I don't know. Thanks, Bob. Check my audio. Thanks, Bob. It sounds fine. Fix your shit. Fix your own stuff. No, I wasn't blamed for it. Mcdonough was blamed for it because he gave the link and he asked if he could share this, and he shared it. And now they're going to do it all quietly and beyond. Yeah, it's going to be out of our hands now. We can't see it. So thanks for the PayPal link there. So new link to Zoom. No, we're not getting one. And if it gets leaked out, he's going to be the one that's held in contempt of court. There's no new Zoom link after that. Did anybody know what was said in chat? I didn't see what was said. I'll have to look back and read it and see it. So let me see if I can see what was said in chat. So I'm sitting here dead in the water. Thanks to those trolls. I'm sure they did it on purpose, but yeah, I don't have chat. Some people are saying I can't change my name, trying to change my name. People really need to learn how to use basic technology. I'm reading the chat here. Hang on. There's nothing in chat. Oh, no, here it goes. Matthew said this case is years old and already been dealt with. He requested the next day. I'm just reading the chat. Does this judge not have all the exhibits in front of him? Matthew says. Yeah, you can't treat this like YouTube chat. That's why I went live. The judge is showing contempt for the public. He's being combative. He should be removed from the bench. Judge is trash. God forbid the public has a voice. Ignorance and power are a dangerous combination. The judge needs to retire. Gascon ETL contacting federal authorities to surreptitiously search Eric's laptop. Yeah, that's what they were talking about, getting fired. The judge is an ass. We will be back, maybe in a real courtroom, and that's it. That's what happened. And it's all those, and that could not be you guys. So that could be any one of us. When I say any one of us, it could be any one of the whatchamacallums. Hang on, let me pull it back up, and we'll watch it. If you guys are just joining in, we'll replay that back. What actually happened there? Just a moment. Somehow I'm on another YouTube. There we go. Wow, we just broke 55,000 subscribers. Thank you guys. I think we had a... That's pretty awesome. Okay, let's jump this over here. We're going to mute this for just a second so I don't get a bunch of audio echo. So if you guys... Close that. If you guys are joining in and you're just watching this, we as a people got all kicked out of this public courtroom. The chat room is essentially the same as kind of like talking in court. You know, it's their platform. This is it. So whoever did that did not sound that derogatory towards judge. Well, they don't want any of it. So. So you can see chat on the right there. And that does have to do with these cases. It is this right here. What I'll just tell you guys what. Oh, you guys can't hear this, right? Yeah. Hang on. Check 1, 2.
What is that?
Audio capture 1.
With this case?
All right. All right, we got the audio fixed on this side with the view up here in the camera like that. Let me scale this down. And we're going to do all of this. Sorry, guys, this is just something that happened here. So anyway, so what Eric Mcdonough was talking about in this instance here is he brought up something that after he did these public records requests and he spoke out about this, the city then started an investigation on him into his work. He's a patent examiner for the U.S. Patent Office, the Federal Patent Office, whatever is there. And this is where he was showing the pattern of practice that they are trying to prohibit him from suing the city and, put intimidation out there. So let's listen to it.
Without the city's instant access to its network, without its ability to text search documents electronically, and without the use of Boolean operators. Anyone with said access could have done a simple Boolean search string, i.e. April space and space 2016 space and space nepotism, hit enter, and in seconds or less, the file would be in their possession.
All right, so he's just talking about how easy it is to search and how it is to find something there. Really easy. I mean, you could find something like that. You could just type in nepotism and it'd probably come up. Richard, thank you for the $25 here. Super chat there. Appreciate that.
I do this routinely as a primary patent examiner for the United States Patent and Trademark Office.
And that's where he's just showing his credibility and what he does in searches, and he has to search millions of different text strings. So
I explicitly note for the record, I am here strictly on my own accord, having nothing to do with my official employment. Why this?
So what he's doing is establishing that by doing these records there, that he has nothing to do with his employment, and they're going after his employment.
Even has to be noted, Your Honor, is the withheld records show that my employer was contacted attempting to have me fired and or to gain intelligence on me because I spoke out and wrote publicly against corruption.
Your Honor,
What does that have to do with this case?
Relevant.
Did the defense attorney cuss? I mean,
Relevant.
Yeah, did this defense attorney here cuss? I think he did.
Wrote publicly against corruption.
Your Honor.
What does that have to do with this case?
Relevant.
Did he say shit? I think he did.
Me fired and or to gain intelligence on me because I spoke out and wrote publicly against corruption.
Your Honor.
What does that have to do with this case?
I think he says don't have shit to do. I think he almost said that. I think.
Relevance. Strike. Relevance.
What's the relevance, doctor?
All right, so that's that part right there. So what he's saying is that
the relevance is I was trying to explain how I was able to quickly find this.
So he's talking about how he gets to quickly find it and on like that. So that's where that came into play. And he was talking about how the courts, I mean, the city contacted his employer, I guess, to intimidate him for doing public records requests.
I'm sorry?
Your Honor, people are also posting on chat and
let's back this up just a tiny bit. Who said that?
Somebody is appearing as me
Yes.
and they're making noise. They're not on mute. Remove them, please.
Your Honor, also,
So listen to this here, the little rat. There's a rat in this thing here, and listen, ready? Here we go.
Your Honor,
I'm sorry?
Your Honor, people are also posting on chat and disparaging remarks about Your Honor as well.
Yes. I just seen that also, Judge.
Let me see one
What happens when you seened something?
moment,
They should.
please.
Your Honor, also, Your Honor,
I'm sorry?
Your Honor, people are also posting on chat and disparaging remarks about Your Honor as well.
Yes. I just seen that also, Judge.
Let me see one moment.
They should be removed.
So what's happening here is due to these people coming in here and even just voicing minor opinions like the judge needs to retire and things like that, the
If they are.
yeah. Now listen to what happens here with the judge. Judge is trying to remove people. It's like asking Gramps to get a VCR remote and program it.
Let's remove me,
You do it. You got the controls, buddy.
Jessica.
You have to do that. Remember to give your removed.
Here's what I'm gonna do. I don't know who you've brought here today,
See what he's saying, who you've brought here. This is blaming it on him.
doctor, but Jessica's gonna send a new link, and you're welcome to appear. Defense counsel is welcome to appear, and witnesses that are being called to testify are welcome to appear. The court reporter, the clerk is welcome to appear. No one else may appear. This is
Yes, sir,
just
Your Honor.
nonsense. This is
I
just
apologize. Your Honor.
utter nonsense. Infantile.
I concur with you, Your Honor.
So now because of that, I hope this doesn't affect his case, which it usually doesn't, but then the judge is going to be just digging into each and every one of those things that he has. But they're going to do it in a private one now. So thanks to me and whoever else those other people were. Not me, but, you know, me there. That's how that goes. And
All right, well, Jessica will send you a new link and we'll log back on in just a moment after everybody else has been removed.
remove.
Yes, sir, Your Honor.
Okay,
Jessica, can you send it to Rodney, please?
Jessica, send it to Rodney.
Yes, Judge.
So that's pretty much what we had there. Let's go back to the beginning here. If you guys want to hear how this judge is right here. Richard, you just can't, in a courtroom, you can't disrupt a courtroom. And that attorney that brought it up was, you know, he's looking for this. He is looking for this to have any kind of conflict in here that makes it look better for them. You know, they have to be. I don't know. I'm just speculating, sir. Let's go back to where official. If you haven't seen that link up there, where Mcdonough gets sworn in.
Order for the
Good morning, Your Honor. Sam Zeskind and Matt.
And I'm going to give you 30 seconds to put your complete name up, or you're going to be removed.
Morning, Judge. I'm the
After the action was amended to include.
I'm going to give each side 1 minute for an opening statement.
So they get 1 minute each, and this judge gave Mcdonough exactly 1 minute, and they gave the defense.
Mr. Dr. Mcdonough, you may proceed.
Your Honor, this case.
Let me find out what this is. Hang on. Oh, you got to hear this. This is great. I mean, it's not great. It's scary at the same time. Where did they put it at? There it is, right here. Okay.
Sorry, Your Honor.
So he just got unmuted here, and listen to this judge, the way he talks to ultimately victims of a public records violation, and that's what they allege here. He's representing himself. Listen to this.
Your Honor, I'm my primary witness, and as such, I request to be sworn in and allowed to provide my testimony in narrative
Raise your
form.
right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Put your hand down.
Raise your hand. Put your hand down.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Put your hand down. Tell me your name.
Dr. James Eric McDonough.
Are you located in the state of Florida at this moment?
Yes, sir. I'm in
May
Miami-Dade.
proceed.
Your Honor, I would like to offer is evidence Exhibit 1. I affirm this is a true representation of the email chain between me and the clerk's office related to the first request. If I may
It
share
is
my
meaningless.
screen.
So he pauses here and waits for this judge to answer a question because he's being like, hand down, hand up, jump, red light, green light, red light, green light.
Is it okay for me to share my screen with the first exhibit, Your Honor? Thank you. Your Honor, this is my plaintiff's Exhibit 1. I'll scroll all the way down to the bottom so we can see the full exhibit. That's the bottom.
So if I pause right here, what he's looking at, he's emailing Elizabeth Sewell. She's the clerk of the court for Homestead, and he says, I'm requesting under Florida Statute 19 copies of the nepotism policy, which was changed in April 2006. Now, that is correct, what the judge was saying, and even Mcdonough concurs. So this doesn't clarify whether he wants the pre-2006 or the 2011. But if you read this by black and white, it is saying that it was changed in 2006. So which one would you go for? I want the one that was changed in 2006. Now, if we go to the next...
Your Honor, we can see that on Thursday, October...
They're admitted.
Thank you. Your Honor, you can see that I filed this. This is a response from the city that was sent on December 13th, where they provide me a copy of a nepotism policy, but it's the 2011 nepotism policy, not the 2006 policy I had requested.
Well, wait a second. You didn't request the 2006
I don't know
policy.
Yes, sir, I did.
That's not the way I'm reading the request.
So the original request is yes, that's there, and then when he gets it, he actually clarifies it, and that's still a request.
The nepotism policy, which you say changed in April 2006. You're not saying give me the policy that was in effect in 2006. So
I was trying to ask for the policy.
We read this differently. You may continue, but I'm not reading this as a request for the 2006 policy. Do you understand me?
So Mcdonough's brain is working very fast. His IQ is well up there in the genius level. I don't know if you guys know that or not. And he's thinking of things that he has to do to counter this, because when you read it in the black and white like that, I'm requesting under the Florida Statute's copy of the nepotism policy, which was allegedly changed in 2006. So he's just saying that there was a policy that was changed in 2006. They're going to give him the current policy.
Yes, sir, Your Honor.
Excellent.
On December 12th, I filed this action. The next day, on December 13th, the city produced me a copy of the 2011 policy.
Objection, Your
So that's what he's saying. They gave him the wrong
Honor.
policy.
Lack of foundation, lack of predicate.
I'm sorry, who's speaking?
Mr. Matt Mandel. I'm handling this witness.
So you're going to understand that both of the parties here are going to get their asses handed to them when it comes down from this judge. It's not a one-sided handing.
On behalf of the city.
Who do you represent?
On behalf of the city, Your Honor, I am counsel for the city.
And you can see that attorney there is, with his voice inflection, is ruffled.
I'm sorry, and what is it that you're objecting to?
I'm objecting to, he's testifying that what was produced to him was a 2011 nepotism policy. I'm objecting as to lack of foundation, lack of predicate. He hasn't established that what's been produced. He hasn't shown.
He's testifying that that's what was produced. You're welcome to cross-examine and show otherwise. I don't understand the nature of your objection. What is your objection? That he's wrong?
That he's testifying as to something that he doesn't have knowledge of. He's saying that what was produced was the 2000.
Your objection's overruled. You'll cross-examine if you wish.
Will do.
Doctor, you may continue.
Thank you, Your Honor.
Now you can see he's updated this right here, and I'm receiving records, but Harvard said you waited after I forced to sue you. So he put the record in, he had to file a lawsuit, they produced it, and then it was the wrong one. What he wanted. But then he clarified what you provided as a nepotism policy for 2011. I explicitly requested a copy of nepotism policy from April 2006, a policy which Raymond DeJohn said was changed in April 2006 and allows relatives to work for the same department. Please immediately provide the request. So you can see that he clarifies it here on What is this here?
Scrolling up to show I
December 13th, I think it is.
responded on the same day on December 13th to the city clerk. And I explained to her that she had provided a copy of the 2011 policy, and it was the April 2006 policy that I had requested. And I asked for immediate production of the remaining policy.
Now, what this judge is doing here is he is expecting Eric Mcdonough here to be an attorney when he's doing these public records and having it, actual and factual, I guess you would say, to the fact that by his request, it made it kind of muddy the waters there with regards to, do you want the 2006 or the 2011? If I looked at it, I would want either the 2006 or the 2011, so I would have to clarify as the clerk and say, which one do you want? There was one that was changed. Do you want the one that was changed, or do you want the one that was there? And then that's what happened. They sent the wrong one to quickly fulfill this. Well, not quickly. He had to file a lawsuit, then fulfill it. And then he clarified it and still didn't get it.
We can see here on December 16th, 2019, Ms. Sewell responded and provided the responsive policy. I'll go ahead and stop sharing this now. Your Honor, after more than a year and a half, city has still not provided a justification for its more than 6-week delay or its delay in providing the record until after the action was filed.
So what they're saying is that he's not suing based off of the wrong record. He's suing even if it was the right record or the wrong record. What it wanted 2006 or 2011, right? So if you get this understanding, he's not suing because he didn't get the 2011 record in totality there, or the 2006. It took 6 weeks. That's what his claim in this is, and it takes no time to do that. So this was an unlawful delay of the public record.
Doctor, I'm just not reading it. You requested a policy and they sent you a policy. You didn't request the 2006 policy. All you said is the policy changed in 2006. Let me have it.
In Your Honor, following your interpretation, I will not argue that. What I'm trying to establish here is that the city didn't produce even the 2011 policy until after I'd filed the action and more than 6 weeks after I'd filed the request.
That's what he's saying right there. That's it. This was an unreasonable delay.
And so this goes to the delay and whether the delay was justified or
Tell
not.
me the exhibits again.
So he's going to read everything again.
You may bring the exhibit 1 up, sir? After the action was filed.
So look at the dates in here.
Okay. Stop. Scroll up.
So what do we have here? October 31st, 2019. Is that when that is? December 23rd, December 13th. So that long. There you go. That's the record time. So what is that? I think he did this in his depositions. I'll be posting the depositions on his page here soon. I have all those copies of that, and it's amazing listening to these people. Now you can see Ms. Sewell in the beginning here has her face on the camera and all of his depositions she did. And you'll see that in a couple of days here. All right, so that's the period of time right there, October 31st, 2019 to December 31st. So November, December would be 2 months. And then you take away November, December, 2 months there. And you take away 13 from 31, whatever that number is there. You can see, yeah, it's a long period of time when this should have taken a week at most. So they're contacting his employer because he has, I don't know if you know, Mcdonough has a lot of case law already. He has a case law that specifically allows us to record secretly the police. He pro se'd that all the way to the 11th court and won. And he has also lawsuits. He's been charged with stalking. He's been charged with all kinds of things. So what they're trying to do is do anything. The city poked the bear, and he's the bear. Mcdonough's the bear.
Okay.
You want me to continue scrolling, Your Honor?
Yep. Thank you.
Would you like me to stop sharing?
Yep.
Okay, thank you, Your Honor.
I'm waiting for a text from Eric there to
So
see
I
if
was
we
saying,
can
Your Honor,
do an interview.
after more than a year and a half, the city has still not provided a justification for its more than 6-week delay or its delay in providing the record after the action was filed. This record was identified with sufficient specificity to allow rapid retrieval. For example, after filing this action, I was advised that the council minutes and agendas were published online. In a time test, I retrieved the responsive document with 10 steps in only 2 minutes and 36 seconds. This
I'm
was
sorry,
done.
say that again?
This judge doesn't understand that Mcdonough was doing a time test. He was saying, I did it in 2 minutes, 36 seconds when it took 6 weeks.
After the request was the record and how long it would take me to find the record, I was able to retrieve the record in 10 steps in 2 minutes and 36 seconds.
Okay.
This was done without the city's instant access to its network, without its ability to text search documents electronically, and without the use of Boolean operators. Anyone with said access could have done a simple Boolean search string, i.e. April space and space 2016 space and space nepotism.
Yeah, I was going to answer something in chat. Yeah, so he has a degree in like thermodynamics. He's a master's or something like that in thermodynamics. So basically, he's got knowledge of things, lots of things. But he's a patent examiner, and he was working on, I think he was working on a patent for the military at this time, or the government, and they were questioning that or something like that, that he can make explosives. Anybody can make that stuff. I mean, it's not hard. Go to the gas pumps. Let me see.
Nepotism, hit enter, and in seconds or less, the file would be in their possession. I do this routinely as a primary patent examiner for the United States Patent and Trademark Office. I explicitly note for the record, I am here strictly on my own.
Who cares, Lucy? Go find somewhere else to figure out your stuff if you want to figure it out.
Accord, having nothing to do with my official employment. Why this even has to be noted, Your Honor, is the withheld records show that my employer was contacted attempting to have me fired and or to gain intelligence on me because I spoke out and wrote publicly against corruption.
Your Honor.
Sorry, what does that have to do with this case?
Relevance.
Curiosity?
All right, we're back where we are. Did he say shit?
What-
I think
Show that my employer was contacted.
I need you guys to listen. 1, if he says shit, and 2, if he doesn't.
Attempting to have me fired and or to gain intelligence on me because I spoke out and wrote publicly against corruption.
Your Honor.
Sorry, what does that have to do with this case?
Relevance.
Curiosity?
Strike. Relevant.
Spoke out and wrote publicly against corruption.
Your Honor.
Sorry, what does that have to do with this case?
Relevance.
Curiosity?
Show that my employer was contacted attempting to have me fired and or to gain intelligence on me because I spoke out and wrote publicly against corruption.
Your Honor.
Sorry, what does that have to do with this case?
Relevance.
Curiosity?
Strike. Relevance.
What's the relevance, doctor?
The relevance is
All right, I'm learning this stuff. You guys know that. Thanks for letting me know I'm muted. We're going to read the news. All right, so we're going to do this right here. We got we ain't got much else to do here. We're going to read some of the news here. U.S. leaves its last Afghan base, effectively ending operations. I guess that's good. I was muted. Do you think he was saying shit in there? Someone put a 1 in there. I think he was saying shit. I don't know. Speculate. And the U.S. economy added 850,000 jobs in June as labor market showed renewed strength. That's good. I'll check the stocks and see what happened. Yeah, it was just me. I'm not good. I don't have a producer. Yeah, it's not bad. I hit a peak of about 1.5% today up. I'm down with that. Cool. And Elsa strengthens into a hurricane, the season's first. And that's coming for me. That right there is coming for me. So I'm a little nervous. Let's see here. How a pro-Trump local news site pushes election information. Wow, that's pretty good. I don't know all this stuff. Yeah, there was some indictment with someone related to Trump the other day. I don't get into politics too much, but Trump was not indicted. But the charges still threaten him. Guess so. And look at that right there. Supreme Court won't overturn a ruling against a business that refused service for gay weddings. They declined to overturn a Washington State Court ruling against the florist who refused to serve gay weddings. That's good, I guess, or not, whichever. What do you guys, we'll talk about that. That's kind of like one of those conflicting ones. Let's look into that really quick. A lot of people, you know, it's a tough thing with human rights and things like that, and people's rights, so. They decided to wade into the contentious issue whether business have rights to refuse for the same-sex wedding ceremonies, despite state laws forbidding them. The court dodged the wedding question 3 years ago in a case involving Colorado baker who said baking a cake to celebrate a same-sex marriage would violate his right of free expression and religious belief. There we go. I think we should all have the right to do that. I mean, business is that. If someone doesn't want to make you a cake, if they commit some type of a crime that says that it's a hate crime, then yes, take it. But if you don't want to make something, I don't think you should. That's what I think. So, yep, that's what I'm thinking. But at the same time, I don't want to, step on anybody's rights to live and if they want to have let me see, hold on, let me close this ad. If they want to have a same-sex marriage and things like that, feel free. I mean, it is anybody's right to want to do that. It shouldn't be anybody's to prevent it. But if there's someone that doesn't want to work it, it's like forcing me to say that I need to make a cake for. I just can't use an example. It's just kind of hard. So they did that. So they're not going to look into that case to the court case there. Barbecue chicken drumsticks smothered in chipotle beer barbecue sauce for July 4th. Yum. It is 4th of July here, and that's pretty awesome. We're celebrating some independence and some freedoms from what? Tyrannical government. Isn't that right? There's a heat wave going through. I've seen that there. Read some chat. Got some free Eric Branson there, yeah. Yeah, find another bakery, or if someone doesn't work for you based off of that, they don't like you for whatever reason, then just move on. First day, religion and expression of free speech and exercising your creativeness too. Yeah, you can do that. All right, pants. State news. Let's see. Where was it? Yeah, this one right here. Washington lawmaker apologizes for wearing a yellow Star of David to protest COVID mandates. I don't know. That's kind of a weird one. I don't really get into the religion thing, but parents of children called Alexa challenge Amazon. I can't ever read headlines really well. Parents of children called Alexa challenge Amazon. Let's see what this is. Oh, goodness. All right, we got the headline. Parents of children called Alexis say their daughters are being bullied because it is the same name that Amazon uses for its virtual assistant. Are you kidding me? That's the headline. So a child that is named Alexa is being bullied because it's the same name that Amazon uses for its virtual assistant. Oh my gosh. She's becoming abused from that. Having abuse from that. She started not wanting to introduce at school because of the jokes and backlash. Alexa is human. Heather says it took a toll. Oh God, they're suing because of that. I know they're going to. Some attorney's going to take it. This is news. I'm going to put a story about that there and just see if it can go weirdly viral. They probably won't, but Johnson & Johnson vaccine seems to stand up against Delta variant. Okay. U.S. sprinter Shaw Carey Richardson suspended for 1 month after failed drug test. I don't understand. If you literally, oh man, if you have drugs found in your system and it benefits you from to win a race, then you shouldn't be suspended. You should be disqualified, period. Hold on, let me see what it is. It might be THC. Oh yeah, it's THC. So they've classified THC in 2021, and it's a 3-month suspension. So you can't smoke. Yeah, it was weed. I'm reading that now. I thought it was like steroids or something like that, or something to make her benefit run faster, but it's not. So that's silly. I don't smoke, never smoked, so. But feel free. I think that's about it. I don't feel like looking at this anymore. Those gas prices. Let's see what gas prices are in the summer. I predicted $4 a gallon. I was a little bit off, but we haven't passed it. This is 21.67. That's a month ago. All right, let's take a look at it right here. Regional gas prices we hit right there for 4. Oh, I did. Wow, that was 2008 though. That was way off. So 2008 it hit that $4.28, 402.8 per gallon. But currently we're sitting at 288 right now. There we go. Gas here is 50 cents a gallon. Where's that at? Yeah, unless you're chased by cops, that's funny. 450. Where are you at, Travis? Like what city? $289.9 in North Carolina. We're waiting for Travis to see where he's at. Stockton, California. Gas prices today. Wow. You ain't kidding. Look at that. 429 is the peaks right there. That's 76. That's I think that's a main road. Yeah, that's like a mainish road right there near residential areas. Got that. Got the service center. Look at that. And that's pretty close to the interstate, so that's one of those ones that that's pretty close. Let's see what we got. Look at that. 406, 420, 446 at the Chevron. $4, $3.90, $4.38. That's an expensive one. 446. Where's that at? Yeah, look at that. You ain't kidding. That's close to your house? Sorry, I don't mean to. Yeah, you live in a high density area here. That's pretty wild. I wouldn't. Let's see what they were on Street View. I love that we can do this now. You know what I mean? Oh, you can drive through the gas station. Look at that. I can look at the sign, but I want to see if I can do that. Hello? This is what's funny when people are like, you can't film me in public. I don't want you to film me. Look at that, 349 right there. This reminds me of the movie Deja Vu. All they have to do is just convert it to video. .345 here in PA. What city in PA? That's pretty good. Soliaker has a doctorate? Ah, are you talking about Soliaker? PC, no. Soliaker's not in here. South St. Missouri. Let's look up that one. What? Yeah, I don't know. That's a lot of money. It's illegal to pump your own gas in Oregon. Wow. I heard about that. I heard that it was like that in Jersey too. Anyway, I'm going to finish this up. I'm going to get out of here. I'm going to let you guys go and watch this video. I'm going to edit really quick and put it up here and talk about this judge and how he acts. I'll see you guys.